Im Namen des Volkes. Erstens.
The Federal Constitutional Court, Guardian of the Constitution.
Absatz 1 in Verbindung mit Artikel 2 Absatz 2 Satz 1 des Grundgesetzes unvereinbar.
Join us for a journey through time. Discover the history of the Federal Constitutional Court. Today, Karlsruhe, the seat of the court, is synonymous with fundamental rights, democracy, and the rule of law, the result of a long journey that has sometimes been marked by conflict. Let's go back to the turbulent beginnings of the Federal Republic of Germany. The Basic Law lays the foundations for a new German state. For the first time in German history, the country has a specialized constitutional court. The court is established in Karlsruhe, deliberately keeping a distance to the federal government, which at that time resides in Bonn. During its first years, the Federal Constitutional Court status is unclear and disputed. In the beginning, the court does not have its own administration and is subject to supervision by the Ministry of Justice. In 1952, the justices call for autonomy and independence in a public memorandum.
The Federal Constitutional Court is a constitutional organ endowed with supreme authority.
The initiative is successful. Since 1953, the Federal Constitutional Court has been independent and has managed its own budget. In 1963, the justices decide on their own official clothing, red robes. These have been inspired by traditional attire worn by judges in 15th century Florence. To this day, they are regarded as the hallmark of the Federal Constitutional Court. The court's independence becomes evident in many decisions. In 1961, the Second Senate declares Federal Chancellor Konrad Adenauer's project to establish a nationwide state television channel unconstitutional. Offended, the Chancellor declares in the Bundestag,
Das Kabinett war sich darin einig, dass das Urteil des Bundesverfassungsgerichts falsch ist, meine Damen und Herren.
Gebhard Müller, President of the Federal Constitutional Court at the time, responds to the Chancellor's declaration of disapproval.
According to the German constitutional order, no constitutional organ is entitled to decide and officially declare that a decision of the Federal Constitutional Court does not comply with the law.
In its early years, the Federal Constitutional Court resides in the Prince Max Palais. Soon more space is required. The court needs its own building. In the 1960s, a modern glass complex is built directly next to the Karlsruhe Palace. A functional building consisting of several square-shaped pavilions, right between the palace gardens and the botanical gardens, without any physical barriers. Assemblies, too, are allowed in the adjacent public area, but require special permission. The court's many glass panels symbolize transparency. In our constitutional democracy, everyone can see how the court gives effect to the Basic Law. Different justices bring differing perspectives to the court, which is very important for its work. In the history of the Federal Constitutional Court, women have been underrepresented. Erna Schäffler was the first and, for many years, the only female justice of the Federal Constitutional Court. In 1994, Jutta Limbach becomes the court's first female president. 25 years later, 9 women and 7 men serve as justices. The Federal Constitutional Court is often called the Guardian of the Constitution. Today, this also means giving effect to constitutional law in Europe and the global community. With the European Court of Human Rights in Strasbourg and the Court of Justice of the European Union in Luxembourg, 2 other important protagonists have entered the stage. European law and international law are much more prominent in the work of the Federal Constitutional Court now than they were in the past. This also raises new questions. How do the decisions of these courts relate to one another? How can disagreement be handled? And how can consensus be reached? Today, as part of their work, courts engage in an international dialogue that brings together all participants of the multi-level cooperation of European courts.
The multi-level cooperation reminds me of a hanging mobile, a structure that keeps differently sized objects in equilibrium. All parts affect each other. If one of them moves, it has an influence on the others. But in the end, all parts are in equilibrium again.
To ensure effective fundamental rights protection, all courts in Europe work together in a cooperative manner.